We've got some fresh new young talent doing some things that I know you haven't heard before.
1, 2, 3, listen.
Welcome to Finances, your home for all things financial, investment, money and lifestyle. Hosted and curated by the very talented team of certified financial planners, Burke, Britton Financial Partners.
Thanks, I suppose, for joining us this evening. I'm Delta Smith. I'm one of the 4 advisors here at Burke, Britton, and this is the very first of our Hot Topics presentations tonight. And just to that point, if you have any particular subjects or topics that you might like us to cover off on, we'd be really open to your feedback on anything that is topical for you and your friends and family. Okay, so tonight's hot topic is wealth protection, and we're very, very excited and pleased to be able to have the talented Daniela Pavlovic Principal of Harwood Andrews, Wills and Estates team joining us tonight. Daniela will be presenting for about 20 minutes or so, and then we'll have a few minutes at the end for questions. So just a little bit of housekeeping. Participants will be in listen-only mode. So if you've got a question that pops up as we progress, you can either use the chat function or make a note, and we'll do our very best to get through each of those questions at the end. Now, for some of our participants tonight who might already be existing clients, and just before I hand over to Daniela, you may be familiar with the jigsaw puzzle that we sometimes refer to in our discussions. And this is probably just a visual of that sort of jigsaw puzzle that we do refer to. And you can see that estate planning or wealth protection is a key part of your financial situation, and having an understanding of how that interacts with other parts of your setup. And I suppose that is the key reason why we team up with other professionals such as Daniela at Harwood Andrews and her team to make sure that all of our clients' needs are met. So I am going to hand over to Daniela and stop sharing my screen for her to proceed with tonight. Welcome, Daniela.
Thank you, and thanks for having me. I didn't realise I was the first cab off the rank with the hot topics, so I'll set the bar, I suppose, for everybody else after me. But thanks for joining tonight, and thanks for choosing this event over watching the block. So I'll try and keep it as interesting as what you'd otherwise be doing at 7:30 on a Wednesday night. So my practice area is wills and estates. I've been doing it for about 15 years, maybe a bit longer. I wouldn't say it's a passion, but certainly something that keeps me motivated and challenged every day. It's a really interesting practice area. I'll talk about wills today and estate planning in a very general sense. A lot of the times when clients call up to make an appointment or contact us to make an appointment, they will ask, what do I need to bring to the appointment? Is there any information that you need? What do I need to think about? And we certainly don't expect you to have all the answers before you come in and see us. But hopefully tonight's presentation gives you just some things that you should turn your mind to before you come in. So you have some idea of what to expect in terms of what we'll ask of you. The first meeting with the client is really a getting to know you exercise. Delta, you referred to your puzzle. I often refer to cogs, and we want to know about all the cogs and how they work together. But I like your puzzle analogy actually too. So the first meeting is really sort of getting to know you, understanding what all the cogs are in your life and how we can get them to work together so that we've got a really good understanding of your personal circumstances, your family circumstances, and your financial circumstances. So before you come in and see a lawyer to talk about your will or your estate planning, what are some of the things that you might want to turn your mind to? The first is, who would you appoint as your executors? So the executor's job is an administrative one. The executor has certain obligations and powers and responsibilities. So firstly, they need to arrange your funeral, have the care and custody and control of your body. They need to identify what all your assets are, identify what your liabilities are, call in and collect those assets, sell or transfer assets to beneficiaries, discharge your debts, finalise your tax affairs, defend any claims that might be brought against your estate, and ultimately carry out the instructions in your will. If you have minor beneficiaries, then those executors also have an ongoing obligation as trustees for those minors to look after, invest and manage the trust fund for those children until they've reached adulthood. The executors also become trustees, and they've got this responsibility to look after and also to use that child or those children's inheritance for their education, maintenance, benefit or advancement in life. Who should be your executors? Well, I can't answer that. It depends. That's such a typical lawyer answer, and I wouldn't be a lawyer if I didn't say it depends at some point in this presentation. There's no ideal number of people you should choose. Most commonly, people would appoint their spouse if they've got a spouse in the first instance, and usually adult children. Whether you appoint one or more of your children depends on the dynamic and the relationships between your children, their ability to make decisions together, ability to act impartially. So that's an assessment for you to make in terms of who the right people are for that job. The next part of the discussion is what we try and map out is think about what your assets and your liabilities are. What do you have to give away? And that might sound like a really obvious thing, but it's not always the case that every asset that you have an interest in is an asset that's capable of being given away in your will. So when we talk about your estate, when we ask you about what's in your estate, what are we asking for? What sort of information are we seeking? So we want to know, what's your personal property? So do you have any real estate in your own name? Do you have shares, cash, other investments, cars, life insurance, where the proceeds are payable to your estate? With your debts, the same thing. Are they secured against assets? Are they held jointly with somebody else? So the assets that are covered or dealt with by your will are your personal assets. Now, what assets are not governed or covered by your will? So any assets that you held jointly with another person do not form part of your estate when you die. So a rule of survivorship applies to jointly owned assets, and that includes real estate, bank accounts, other assets. And when one of the joint owners passes away, his or her interest in that asset automatically extinguishes, and the surviving owner automatically acquires the deceased person's interest in the asset. So if you jointly own an asset with someone else, any gift in your will in relation to that asset is ineffective. If you control assets via a family trust, you can't give those assets away in your will. I'll talk to you a bit more about family trusts later on, but assets held in family trusts belong to the trust and not to the individual beneficiaries. Thirdly, superannuation. So superannuation might be dealt with by your will, but in the first instance, you need to give directions to your super fund about how to pay your benefits out on death. That's another topic I'll talk a bit more about down the track. So once we've mapped out your financial position, what you own, what it's worth, what's in your estate, what's outside of your estate, we start the discussion about, okay, well, who's to benefit from these assets? Who are your beneficiaries? We start with specific gifts. So is there anything in particular that you want somebody to have? Jewellery, sentimental or family heirloom, personal items, a gift of money or a particular asset. If you've got property that's subject to a debt and you want a particular beneficiary to have that property, so an investment property that's got a mortgage attached to it, is that beneficiary to receive that asset subject to the debt, so they take on the property and the debt, or do other estate assets get used to discharge that debt and the beneficiary receives the property free of any encumbrances? We also then have a discussion about what's the nature of that gift. Is it an outright gift to somebody, or do you look at other ways of benefiting a beneficiary, such as giving them like a right of occupancy in a property or a life interest where they have use of that asset for life, but ultimately they never have the legal ownership of that asset? If you're giving specific gifts to somebody, have a think about what happens if you no longer own that asset when you die. We generally discourage clients from picking and choosing assets to give to certain children, apart from your sort of jewelry and personal and sentimental items, we would generally discourage clients from saying, well, I want this child to get a particular bank account, I want this child to get a particular property, because things change. And if that asset no longer exists at the time of your death, the gift can fail and the intended beneficiary might not get what you intended them to get. Now, you might say, well, I'll never sell that property, but you could lose capacity. Your attorney might sell it on your behalf, for example. So once we've set out your specific gifts, we say, like, well, what happens with the rest? So we've segregated out your specific stuff. After all your debts are paid, your taxes are paid out of your estate. We call that the residue. Who gets that? They're your residuary beneficiaries. So that often is divided up in percentages or proportions to amongst the beneficiaries. You have to think about who benefits. Also have a think about if you've nominated a person as a beneficiary and they die before you, what happens to their share that they would have otherwise received? Does it pass down to their children? Is it absorbed by the surviving beneficiaries, or does someone else get it all together? One area that we see a lot of issues with when parents in particular pass away, if you've made loans or gifts to a child, think about how those types of advances are to be dealt with. You'd be surprised how many disputes there are amongst siblings about whether certain financial benefits or advancements given by the parents during lifetime are gifts or loans. So not all benefits that you provide to a child during your lifetime are intended to be equalised or accounted for after you die, but maybe some are. So if you've made those sorts of gifts or loans, have a think about what happens on death. If it's a loan, is it repayable on your death to your estate? Is it forgiven? Is there to be an adjustment in favour of other children to sort of equalise that benefit? So they're all sort of little traps that you need to be mindful of. If you do advance money to your children, actually think about what is the true nature of this. Is it a loan? Do you have any expectation that it will be repaid back? Do you have a loan agreement? Have you got some sort of security for that loan? Is it a gift? If it's a gift, it's irrevocable. You can never get it back. Those sorts of things really need to be carefully considered. If you've got young children, think about who the guardians of those children will be. So the executors have the financial responsibility of administering your estate. The guardians are the people that you nominate to actually look after your children. Quite often it's the same people, but it's not always the case. If you're not appointing the same people, think about whether the executors and the guardians can work together, whether that's a functional relationship. If you've got a blended family, that's a really tricky scenario because we have to consider how you juggle is probably the best word for it, how you juggle your obligations to provide for your spouse versus your obligations to provide for your children, and perhaps managing your children's expectations around that. There's different strategies that we can use to reduce the risk of disputes after you pass away. So we can look at life interest, for example, again, or mutual wills agreements where couples essentially contract with each other to make their wills on certain terms, and part of those terms are that the survivor won't change their will or do things to deliberately diminish their estate after their spouse's death, so that the intended beneficiaries ultimately sort of have security that they will inherit what their parents intended them to get. If you've got vulnerable beneficiaries or beneficiaries with a disability, then we need to look at trust arrangements. When I mean vulnerable, I'm not talking about people who make bad decisions. People are entitled to make bad decisions. So it's not about whether you agree with how they'll spend their inheritance. I'm talking about people who have a lack of capacity to manage their inheritance. So, someone who might have a cognitive impairment or some severe mental health issues, drug or alcohol abuse, gambling issues, You might have a beneficiary who's exposed to some financial risks or relationship risks as well. It's a different kind of vulnerability, and we can provide for different types of trusts in your will. So you can provide for particular trusts for disabled beneficiaries. You can establish a testamentary trust in your will, and a testamentary trust is essentially a family trust that is created by your will. And the benefits of a testamentary trust is that they provide some asset protection for the beneficiaries, because the trust owns the assets, not the individuals. So if any of the individual within that group of beneficiaries is at risk, there's a level of protection afforded by the testamentary trust. So it's really important to have some special consideration about the structure of your wills if you do have some vulnerable beneficiaries in the mix as well. So quite often in our meeting, we'll ask you, a fair bit about your intended beneficiaries. Are they in a relationship? Do you consider that relationship to be stable? Are there any financial risks? Are there any disabilities? Those sorts of questions. So we've got a good idea of who's in the mix and are able to provide you with some advice about how you can protect an inheritance and how you can best provide for those people. We then have a review of your superannuation. So I said earlier that your superannuation is not covered by your will, and we need to decide who's going to get your super and how they're going to get it. So the distribution of your superannuation benefits on death is governed by separate laws to your will, laws around wills. And if you're a member of a super fund, when you die, your superannuation entitlements have to be cashed out on your death. And your superannuation entitlements can be paid directly to a dependent. So a dependent is your spouse, a child of any age, or a person in an interdependency relationship with you. If the benefit is paid directly to a dependent, it bypasses your estate altogether. It comes directly out of your fund into the hands of the dependent. You also have the capacity to nominate your estate as the beneficiary of your super fund. And in that case, your superannuation benefits will be paid to your executors. They'll form part of the asset pool of your estate and then be governed by the terms of your will. Now, if you have superannuation benefits, your fund will allow you to make a binding death benefit nomination. And a binding death benefit nomination is a direction that you give to the trustee of your fund about how you want your superannuation benefits paid. Binding death benefit nominations are really important. If you don't have a binding death benefit nomination, the trustee of your super fund has the discretion to decide, the power to decide how your superannuation benefits will be paid. So all potential dependents are then invited to submit a claim for payment of your superannuation benefits. And the trustee of that fund ultimately makes a decision about how that benefit is paid. And you can see that that's a real opportunity for disputes. So to avoid those types of potential disputes and to have some certainty about how your superannuation is paid on death, we recommend that you have a binding death benefit nomination in place that gives that binding direction to the superannuation trustee about how to pay your benefit. Now, how do we sort of make an assessment about whether your superannuation should go directly to a dependent or to your estate? There's a few different things that we look at. One is the tax consequences of the payment. So payments to dependents who are what we call tax dependents are tax-free. So tax dependent is your spouse and minor children, essentially. So we look at who can receive your superannuation on a tax-free basis, and I would generally recommend you funnel your super to that person. We look at risk, and in terms of risk, we look at the risk for the recipient versus the risk of bringing it into your estate and having some dispute around the terms of your will. Sometimes we want to make sure your superannuation doesn't come to your estate because you might be expecting a dispute or a claim against your estate, and we don't want to bring your superannuation in and expose it to that legal dispute. So we want to be able to quarantine your super and make sure it's not exposed to that will dispute. Other times we want to bring your superannuation into your estate because we want to be able to deal with it via your will. So you might, in your will, have that testamentary trust established. And if we bring your superannuation into your estate, then the superannuation benefits will flow via your will into that testamentary trust or into a special, what we call superannuation proceeds trust established by your will. So they're sort of structural decisions that we make, and you make, not so much we, but you make, based on your particular circumstances. You might not have any dependents. So if you're a single person, you're not in a relationship, you don't have children, you can't nominate your friends or siblings or a charity to receive your superannuation. So the only way that you can deal with your super is to nominate your estate, and then via your will, you can give it to whoever you want. So it's really important that you separately consider your superannuation benefits. It's another cog apart from your personal estate. Then we look at existing trusts. So some of you might be trustees of an existing family trust or directors of a corporate trustee of a family trust. And my experience is that clients generally don't understand or aren't aware that they don't legally own the trust assets. So for all intents and purposes, on a day-to-day basis, you make all the decisions in relation to those assets, but they're not legally yours. It's actually the trust that the assets belong to the trust. Now, you might be a trustee, which means that you control the trust, and the trustees have a responsibility to invest and manage that trust fund for the benefit of the beneficiaries. So if you have an interest in a family trust as a controller, whilst you can't give away the trust assets, you can give away the control of the trust. So separately to your personal estate and separately to your super, we also look at your interest in family trusts, and we have to make sure that that cog also works with all the others so that there's a succession of control of that entity if you pass away or if you lose capacity. So they're all the different moving parts that are in play when it comes to estate planning and your will. The other really important aspect is also around what happens if you lose capacity during your lifetime, but you don't actually die. So your will doesn't take effect until you pass away. The executors that you appoint in your will have no power or authority to act during your lifetime. So we recommend that you make powers of attorney as well. And powers of attorney are documents that operate during your lifetime, and they give authority to people that you nominate to make financial, personal, and medical decisions on your behalf. So those are equally important as making a will. So that's sort of a estate planning 101. I could probably talk underwater for hours if I had the chance.
You make it sound easy, Daniela.
Bit of ground in a short amount of time. Do we have any questions?
I haven't had any come through the chat, but if anyone has any that they want to raise while we've got you on live, we can answer them.
I actually have a question.
We got one.
For Danielle.
You can go, Jan.
Okay, thank you. With the rule of survivorship and jointly owning a house, I have a husband who's lost capacity and is 67 in a nursing home. I'm not pension age. And I'm quite concerned that if I predecease, he gets the entire house and that gets sold and that. But I'm just wondering how to protect even my half for our adult children, that it doesn't become a financial burden for them.
That's a really complex question, Janet.
I know.
That it is. The difficulty you have is that your husband's lost capacity. Any steps that you take to deal with the ownership of that property could be perceived to be you acting where there's a conflict of interest. So the other question is, are you his power of attorney already under an existing document?
Yes. Yeah.
So you could, in theory, take steps as an attorney, but I think you'd arguably be breaching your duties as an attorney. It is possible to sever a joint tenancy, so you can sever that rule of survivorship, and where your ownership would revert to what we call tenants in common, where you each own 50% of your property. And if you pass away, you can, via your will, deal with your property in a different way, like give it to your children, whatever it is that you plan to do. But it's difficult to unilaterally sever a joint tenancy. So obviously it would be much better if your husband was capable and he could consent to that, but he can't. The other option is that you can actually make an application to VCAT, which is the Victorian Civil and Administrative Tribunal, and you can ask VCAT to essentially sign off on a transaction that you're proposing to undertake as an attorney, or give you an advisory opinion about what you should or shouldn't do as an attorney. So your options are fairly limited. It's not impossible for you to take steps, but it's not easy.
Yep. Okay. Thank you.
Thanks, Jan. Are there any other questions from the audience?
If we've got...
I had one. I had one, Daniela. I know you and I've probably asked you 1,000 questions over the years. One that came up recently for me, which is probably topical around sort of digital assets, cryptocurrency, was what have you seen or how have you dealt with potentially digital assets? So, for example, the likes of cryptocurrency that is maybe not held on an exchange, so doesn't have an ownership, but maybe just have a digital key to access. What have you seen in terms of the issues or risks or even ways of dealing with this new type of asset?
Well, it's something that we're just it's constantly evolving, Jay. And a similar thing came up recently in terms of frequent flyer points when somebody passes away. And we are more and more often now including clauses in wills dealing with digital assets. So each of, separately to cryptocurrency, I'm talking about things that are more common. So people's like Facebook, Instagram pages. People might have like works of art on their Instagram pages. There's photographs, there's memories. Each of those platforms has its own rules in terms of what happens when an owner passes away. Cryptocurrency would just be dealt with as the same as any other asset in terms of the authority to deal with that asset passing to your executor. I don't really know in a real sense how I'm assuming you can treat it as you would a bank account or any other asset. But once you've established your right to transact or deal with that asset by proving that you're an executor or an administrator, then you can do everything with that asset that the original owner could do. So transfer, redeem, whatever it is that you can do with that cryptocurrency. I'm not sure that answers your question, Jay, but it's certainly something that it's just constantly evolving.
Yeah, I think it's certainly a complex one and one that I haven't thought through every possible angle. But I think that idea of with cryptocurrency in particular, really the access to that asset is the digital key, which isn't necessarily the ownership structure is the blockchain. So it doesn't necessarily have an ownership structure, which is why some people lean towards having the currency on an exchange, which then can have ownership. But yeah, it's a very interesting topic, probably one for another podcast, maybe, Daniela, in the future. But it's something that we're getting more and more interest and questions around. So it's probably something we can explore in more detail in the future.
Yeah.
But yeah.
There's other people in my office who've actually got a real keen interest in like digital planning in terms of estate planning. So I'm not the person to ask that question, but we certainly have a cohort of people, some younger ones who have a real keen interest in how you deal with these digital assets, because I think the technology is advancing much more quickly than we have the capacity to build rules around it from a legal perspective in terms of, okay, what happens if you lose capacity or what happens if you die? What are the rights associated with that asset and how do you actually, in the real sense, deal with it?
Great question, Jay. And just in the interest of time, Daniela, we're just a couple of minutes over. So are there any other questions that anyone would like to raise? We've probably got time for one more.
I've got one, Delta, if that's okay. Just a quick one. Hi, Daniela. Me and my partner came and saw you when we had our first child about 8 years ago. So thank you for that help. My question's just around how often you should take steps to update your details. Obviously, now we have 3 children, and I guess a lot of other things have changed as well. So how should you go back and relook at what that will looks like and kind of update it, I guess?
Yes, absolutely. That's a good question. And it sounds like I planted it, but I didn't. That's a really great question. And we would generally say review your documents about every 3 to 5 years. And that doesn't mean that you need to make new documents all the time, but just get into the habit of checking what's provided for, who's appointed in different roles, or if there's also a change in circumstances. So if someone dies or loses capacity, you have a falling out with them, those sorts of things. We probably have already allowed for future children. I can't remember what we did, but often we allow for future children being born. But you might have appointed an executor or guardian that you think now, well, I wouldn't be comfortable with that person in that role anymore. They might have moved away, you might have had a falling out, you might think there's too much going on in their life. I wouldn't want to give that responsibility to them anymore.
What about, Daniela, in terms of assets and debt, if there's a major change, like if you paid down a house or you bought another house, are they reasons to go and get your will updated, or it really just depends what you originally put in there?
Yeah, it just depends. Quite often just a change in financial circumstances like buying or selling a new house don't warrant the making of a new will unless you've specifically dealt with that asset in your will. So if you've did a particular property or given rights to a particular property to a beneficiary and you then sell that property, yes, that's a circumstance where you'd want to review your will. If in doubt, just check. That's what my advice would be. The other thing is where you've got young children, the big change usually, or the big sort of redrafting happens once your children are adults, because at the moment you're relying on other family members or friends to fill roles that adult children would ordinarily fill, like the role of an executor or a substitute power of attorney. So once your children are adults and responsible, and you trust them with that sort of responsibility, then you would replace your executors with your children. Sorts of things.
And Daniela, that's probably a really good segue into just wrapping up tonight, and I suppose reiterating at the comprehensive nature of the discussions that you obviously have with clients that come in to see you, and why we work with professionals such as yourself, and the cogs or the jigsaw puzzle analogy in having professionals that work in your corner to ensure that the right things are in place, considering advancements, guardians, blended families, trusts, what do we even have that forms part of our estates, and nominations and things. So I suppose that all comes back to being proactive in that space and being prepared before the need for any of those things might arise. We're probably just at time for tonight, but I'll just encourage anyone that's joined us, if something in the presentation has popped up that's perhaps relevant to you, your family, your friends, feel free to reach out to the team here at Burke Britton. We've also got the ability to book a meeting online, and same for the Harwood Andrews team. And just a bit of a shameless plug, Daniela has appeared on our podcast Fine Answers, for anyone that hasn't heard that yet, episode number 27, Leave a Legacy, Not a Mess. So that could be just a great way to perhaps revisit some of the points that Daniela's touched on tonight. So we will leave it at that. If there's any other questions, feel free to send them through to the team. Thanks everyone for joining.
Thank you.
Enjoy your evening.
Thanks, Daniela. Thanks, Delta.
We hope you enjoyed today's episode. If you're keen to understand more about how financial advice could benefit you, follow us on Instagram, Facebook, and Twitter at Burke Britton FP, or Google Burke Britton Financial Partners. Check out our client reviews, testimonials, and make a time to meet one of our certified financial planners by clicking Book Now on our website. Thanks for listening.
Any information contained in this podcast is of a general nature only. No account was taken as to the objectives, financial situation, or needs of any particular person. Therefore, before making any decision, listeners should consider the appropriateness of any information with regard to their particular objective, financial situation, needs, and seek independent advice from a licensed professional specific to their circumstances.
All right, hit it.
That translates to, don't be a moron and act on what some random person says on a podcast. Take personal responsibility, do your homework, ask questions, and speak to an actual human that knows what they're talking about before you do anything. PB Financial Solutions Proprietary Limited, trading as Burke Britton Financial Partners, are authorised representatives of AMP Financial Planning Limited, AFS, licence number 232706.